Social welfare statutes are enacted to promote social justice and provide benefits to the people. For example, the Mahatma Gandhi National Rural Employment Guarantee Act, the Right to Education Act, the National Food Security Act, or the Rights of Persons with Disabilities Act. Since the objective of such statutes is to extend benefits or to ensure the welfare of the people, they should be interpreted beneficially and liberally to ensure that all the intended beneficiaries are covered. For example, if there are some benefits that are to be extended to people with disabilities, and there is a question about some disabilities that are not specifically listed in the statute, then the court can use common sense and reasonable construction to see if the disabilities in question should be covered under the statute or not. If there is a reasonable doubt, it should ideally be interpreted in favor of the beneficiaries, because it is okay if a few unintended persons benefit from the statute. No intended beneficiary should be deprived. As is the case with all statutes, if there is a need for interpretation, the primary rules are applied first, and then for social welfare statutes, the court should use beneficial interpretation. Another point to remember here is that social welfare statutes should be interpreted dynamically to ensure that the statutes stay relevant with the changes in the society. For example, there are some laws and rules that offered some benefits to people working in offices. And after the COVID pandemic, working from home also has become normal, which means that the statutes that covered work from office should be suitably interpreted to cover employees who are working from home also. And any interpretation of any statute must be validated against the presumptions as to interpretation of statutes.